All right, bye-bye.
Bye-bye.
Connected, and it appears that everyone is. This is the Garcia hearing, Garcia Clinical Lab. If you're here on another hearing, or if you don't have a speaking role in this hearing, please mute yourself so we don't get background noise interfering with our ability to make a record. And this is being live streamed for everyone's information. This is Garcia Clinical Laboratory, Inc. versus Professional Laboratory Services, LLC et al., docket number 21-703CB. I have several motions set for this afternoon. The first one up is the plaintiff's renewed motion for a preliminary injunction and for sanctions. May I have appearances, please, for the record? Plaintiff first.
Yes, Your Honor. Michael Donnelly on behalf of the plaintiff. I also have my colleague Kirby Albright here as well.
Catherine Wood on behalf of the defendant. My colleague Maureen Moody is here with me today. Mr. Knapp, Your Honor, wished me to extend to you his apologies for not being here. He intended to be. He was called to a family funeral. Thank you.
Oh, I'm sorry.
Your Honor, I apologize. I have one more colleague here. Laura Fossier is also joining us.
All right, thank you.
Your Honor, I'm Scott Story here for Foster Swift, which is the deponent of the subpoena that's subject to one of the motions.
Yeah, that's coming up later if you can just sit tight. Okay, so as I said, this is the plaintiff's renewed motion for a preliminary injunction, and I don't know if Mr. Albright or Mr. Donnelly's taking that, but you may go ahead when you're ready.
Thank you, Your Honor. Michael Donnelly again on behalf of the plaintiffs. Your Honor, this is our motion for sanctions as well as for the preliminary injunction. Your Honor, we have seen in this case now a pattern in practice of deceit and dishonesty by the defendants, both before they left Garja, after they left Garja, and now, unfortunately, in this lawsuit. Your Honor, we have uncovered much evidence through production of documents that show that, including before they left Garja, they were acting not in the best interest of Garja as their fiduciary duties required them, but were in fact acting on their own behalf. We have a document, Your Honor, and if you would indulge me to share my screen, we have a document produced by the defendants in this case. Let's see if we can get it correct. Okay. I think you can see that now, Your Honor. It is a email. The top email is from Rochelle Maurer to Colin Smith, but the substance is a forwarded email from Christopher Radicki. Christopher Radicki is a representative of Beckman, a company that supplies testing machines. What appears to be going on here, and we haven't gotten the full email string, we're still seeking a substantial amount of documents to be produced, but what we see here is that Rochelle and Colin Smith are obtaining a lease and purchase quote from that company. What makes it interesting is two things. One is the date, October 14th, 2020. We know from what we'll deal with on the issue of the privilege log is that Colin Smith was regularly corresponding with his attorneys, Foster Swift, prior to October 14th. So at this point, he has fully engaged in the leaving of the company and starting his own company to directly compete. The second interesting thing here is that this email is sent not to Rochelle and Colin's business address, but to their home address. So it appears to us that they were getting essentially a quote under the name of Garja for these test machines. But we're using Garja property and time to get these quotes in order to start their own business. Secondly, Your Honor, we know that the defendants, or at least Colin, surreptitiously taped Dave Garja prior to leaving. None of the defendants disclosed where they were going. Even after they left, they actively used Garja documents to get quotes from vendors, develop projections, and develop policies. They also had an iron-fisted confidentiality demand with their vendors, where they didn't want to disclose even the existence of PLS to Garja Lab or otherwise. Your Honor, we know now what has occurred in this case and the dishonesty in these filings of not only the initial affidavits, but the subsequent affidavits. Your Honor, this is not the activity of people that want to have fair and honest competition. They understood they were doing something wrong. They tried to hide it from Garja Lab because they knew once Garja Lab determined that they had taken the documents and they were directly competing and interfering with their relationships with their clients, a lawsuit would be pursued and discovery would be pursued. So as you know, Your Honor, we did in fact file this claim, bringing among other things, breach of a confidentiality agreement, misappropriation of proprietary and trade secret information, and breach of fiduciary duty, among other things. We did seek immediately a TRO and a preliminary injunction to stop them from using what we knew to be documents they had taken from Garja in order to assist them in starting PLS. And plaintiffs responded essentially by saying unequivocally, we did not take anything, not one shred of paper, not one electronic file from Garja when we left. Ms. Wood repeatedly claimed that we did not have the evidence to support a claim for a preliminary injunction, that it was mere speculation that they had taken anything. And in fact, she cited the Degussa case repeatedly, saying that kind of speculation is not the basis for a preliminary injunction. We know now, Your Honor, that the situation was very different. But at the time, this court and the parties had to rely on the evidence as it was submitted by the defendants. The defendants submitted affidavits, which, as I mentioned before, unequivocally stated that they did not take any documents. This court, in analyzing the plaintiff's motion, relied on those representations and said that we had failed to meet our burden to show that they had taken and used confidential information or any information at all from Garja. The motion was denied, and what was clearly a continuation of the pattern of dishonesty, defendants made very clear what they wanted to do. They wanted to bull rush this case very quickly. They immediately filed a motion to dismiss. They immediately set the deposition of Dave Garja because they knew that they had to try to get this case dismissed before discovery commenced. It was very clear that once we peeled back one layer of the onion in this case, the floodgates would open. So they not only filed the motion to dismiss, but they had the audacity, Your Honor, to send us a sanction letter saying that we had failed to produce a case we had failed to do our due diligence. Well, we know now that they lied to this court, they lied to us, and they even lied to their own attorneys, Your Honor. And they were successful to that point. We filed a response to their motion to dismiss, and they in fact withdrew that motion. They understood that there was no way they were going to win that motion now based on what we knew. Your Honor, we know that the defendant's counsel had to file an ethical disclosure admitting that the affidavits submitted by both Colin and Rochelle were in fact false. And as we began to dig through it and see what we were getting through discovery, Your Honor, it became patently clear that they had done more than lied, but they are continuing to lie to this day to the court. So let me move on to the affidavits in particular. Colin's affidavit He submitted two, one on December 22nd. Again, he said in paragraph 21, unqualifiedly, I did not take any documents from Garza when I left. We know that is now false. And it was something he absolutely knew at the time was false. His response in his new affidavit, Your Honor, is, I'm sorry, I forgot that we had those documents. Your Honor, that is beyond incredible. It's beyond credible, and it should, I hope, be as insulting to this court as it is to us at this point. It's not as if he is in some lawsuit with a vendor that he dealt with a year ago, and there's a box of documents sitting in a conference room somewhere that he forgot about. This is his nemesis. He has said it's his nemesis. He planned to take business from this company. He accessed these documents. We know he accessed these documents because he used them, as we pointed out in our briefing, Your Honor. He used them to get bids from various vendors. So for him to say he simply forgot about these documents is outrageous, and it's a second lie to this court that shouldn't be tolerated. Quite simply, it's just an out and out lie. So far, the production has been very thin. We are still awaiting a number of documents. We have sent a demand letter to Ms. Wood to supplement her responses. What they lack in substance, they've made up in volume. So we have a lot of pages, but not nearly enough responsive documents to our very well-tailored request, Your Honor. We have discovered through the production that Colin had access to and a copy of Garza's utilization report with regard to the Tennessee Department of Corrections. And why this document is so important, Your Honor, one is because if he just had it, would be bad enough. This is a document that shows what the amount of tests, the types of tests that they use with the client Department of Corrections in Tennessee. So it has vital information for not only determining what has been sold, the prices that they've been sold at, but also for future projections in terms of determining what they will need to purchase in terms of testing going forward. But what we got produced was not simply the Garza utilization report. What we got is the Garza utilization report with a PLS utilization report embedded inside of it. It's exhibit number 1 to our motion, Your Honor, and I apologize because of the way that Excel prints out. You have to go through 30 pages of the one tab to get to the second one. So I know that probably wasn't enjoyable to read, but the reality is on tab 1 was the Garza utilization report. On tab 2 was the PLS utilization report. There is no credible reason that those two documents are embedded together, other than the fact that Colin was using the information from Garza to develop his own projections. And in fact, at one point, he sent the whole document to a vendor, to McKesson, to get a quote. He later sent it and said, oh, didn't mean to have that other stuff in there. Well, he can't back out of it now because we know that he was using that document for advancing PLS's business model and their work and their relationship with McKesson. The second thing I want to point out about Colin's affidavit, Your Honor, is regarding Foster Swift. In paragraph 25, he's in the December 22nd affidavit, he says that he had no contact with Foster Swift regarding PLS, period, end of statement. The reality is we know now from the privilege log that he had extensive communications with Foster Swift between October 8th and October 22nd, and that they involved things like WBE status, due diligence, corporate formation, letters of intent. So we know he was having conversations about it. Now, if he tries to say something to the effect of, well, that was regarding MLS, Your Honor, they're the same company for all intents and purposes. One is the sole shareholder or sole member of the other. They operate in tandem. So even if he tries to say, well, I just meant that I didn't talk about PLS, I did talk about MLS. Well, that's not a sufficient answer, Your Honor. That's not being forthright with this tribunal. And we can see that this pattern of deception and dishonesty is just continued, even in subsequent filings with the court. Your Honor, those are the two sort of highlights from Collins' affidavits. There's so many, Your Honor, that quite frankly, it would take me all afternoon to go through all of the evidence that's submitted. But I think we've established that Collins' affidavits are false. Both of them are false now. In fact, we know that Collins took out in his second affidavit the statement that he did not have any contact with Foster Swift, and replaced it with saying that he was not involved in the choice to hire Foster Swift. So that's a long stretch. So, Your Honor, I'm going to talk now about Rochelle's affidavit, and hers are perhaps even more incredible than Collins. Rochelle, just like Collins, categorically denies taking any documents from Garcia. Paragraph 15 of the November 17th affidavit. It was not qualified. She said it unequivocally. We know through the production that there are a number of documents that were apparently included on her Google Drive. Now, the production that has been given to us has not identified where any of the documents have come from or what specific requests they're responsive to. So we are at a bit of a disadvantage, but fortunately, in trying to cover up her lie, Rochelle has been able to explain to us that many of these documents came off her Google Drive. She has admitted, she doesn't dispute, that there is a trove of documents on her Google Drive that are Garcia documents. Her excuse seems to be that when asked, I assume by her attorneys, when asked what documents she had, she was thinking about things like pricing and contracts. Your Honor, I've been doing this type of case for over 20 years, and I know that Dickinson Wright is a good firm, and I can guarantee you that they asked her, I want to know every single document you have. I don't care what it's about from Garcia. You're being accused of taking documents from Garcia. I want to know everything you got from them that you have in any spot. And she chose not to produce those, and she chose to say she had nothing. And not only is that a ridiculous response by denying that she was thinking of any other type of document, we've now find out that there are 760 Garcia documents on her Google Drive. We have not seen them all, Your Honor, but this isn't a small error. This is an error of magnitude in this case. She knew she had these documents because the rest of her affidavit goes through and admits that she's been using these documents to draft policies for PLS. So she knows she has access to them, just like Colin was using one of the documents and then tries to claim he didn't remember that they had the documents. It's absolutely outrageous that they would come back again, Your Honor, and claim that they simply forgot or they misunderstood what a document is. Specifically with regard to what Rochelle is claiming, she admits to using the procedural manuals. Now, in the procedural manuals, Your Honor, are drawn up pursuant to the College of American Pathologists. And it's basically a checklist that says, if you're going to get certified so that you can get paid by Medicare, you need to have a policy that covers certain areas so that it is so that you can get approved. The checklist is just that. It says you have to have a policy on X. And so the job of the lab is to develop a policy that is specific to their industry, that is specific to their company, and is tailored to their needs. And so that's exactly what Garcia did. And in fact, Rochelle was involved in that process with Garcia. They drafted this document. It's not something you can go onto the internet and simply cut and paste. You have to develop it based on your use, based on your needs at your company, so that it is approved. And in the Exhibit L, if you look, there's a protocol that says, a notation, I should say, that says GEN.41306, for example. The numbers have changed. That is a reference to the checklist that says you must have a paragraph about X. Then you put in your own paragraph X. So Rochelle has attempted to say, I can just get this off the internet. Well, one is she didn't. And she even admits that. She says, yeah, I have been using them. Well, that means there's value to her and to her company to use those, Your Honor. They're not readily available. They've been vetted. They're based on long-term experience, and they have been used. I mean, one thing we do look at is you cannot say to them they have no value, and they use them instead of going on the internet. Even if they go on the internet and get certain materials, that takes more time. That takes more effort. And that means that the products that they stole from us, the protocols, the procedures manuals, have economic value to them. And they stole them, and that's why they did it. One in particular, Your Honor, the fire safety protocol, Rochelle admits openly that, yes, she's basically copied that one over from the Garja one. And she admits that there may be many more. She's obviously understands that forensic imaging is going to be a problem for her, so she better leave the door open. But regardless, Your Honor, there is no question that both Colin and Rochelle came into this lawsuit with the predisposition to say, we're going to lie our way out of it. We're going to get out of this case. We're going to put pressure on Garja because we know they don't have any documents because we took them, and they have no evidence of that until they image our computers. And they wanted to get in and out. So they thought, let's tell a lie first, see what happens. And they lied to us, Your Honor. They lied to the court, and they even lied to their own attorneys, putting them in the awkward position of having to file an ethical disclosure. So, Your Honor, I think we've established through our briefing, and hopefully I've been able to articulate today, not only these extremely outrageous behavior by the defendants of lying consistently from back in the time when they were still with us, but through this court process. And quite frankly, Your Honor, it's one of the most egregious examples in my career that I've seen of somebody lying and then lying again in a subsequent affidavit. In terms of our preliminary injunction, Your Honor, there's no question that we are in a much different position than we were the last time we met. Our likelihood of success obviously is based on the production, a huge production, and we're not even done yet, of documents that they clearly took from Garja. We've established that cannot be refuted. We've established that they are in fact protectable interests, individual documents developed by Garja that have an economic advantage for a competitor to use in starting up the company. We have evidence of activity prior to leaving that violated their fiduciary duty. And I think, Your Honor, despite what appears to be a conflict between the parties of one saying it's confidential, the other saying it's not, it's readily available. One is, I would hope the defendant's credibility does not warrant believing their position. But secondly, Your Honor, I think you just have to look at what they've admitted to doing with these documents. If they have no value, if they're readily available anywhere else, then they could have gone and gotten those, and they didn't. They chose to use the Garja documents. In terms of irreparable harm, Your Honor, we've determined through the discovery process that Garja faces the loss of its largest client. It is essentially one signature away from losing the Centurion contract, a contract that was interfered with by PLS with the help of all of the documents and the use of the development. It allowed them to get up to speed and get up and be functional quickly enough that it could go after Centurion, Your Honor. So there's no question, and that's only one of the many customers. One of the things I failed to mention with Rochelle's affidavit is she said in the one that she had no contact with any Garja client except a friend that she had met. In the subsequent affidavit, she chronicles meetings with two Garja clients and making pitches to them. So she couldn't even be honest in that regard. In terms of the harm to the defendants, Your Honor, they keep claiming that they're not generating any revenue and that they haven't won any contracts. So prohibiting them from contracting with any Garja clients, at least for the duration of this lawsuit, will not harm them in any way. And obviously, the public policy supports our claim. Certainly, we don't want to support people who are liars in their affidavits. And public policy supports enforcement of confidentiality agreements and certainly supports fair competition, which we have not had in this case. So, Your Honor, I know I've taken a fair amount of time. I will say that in terms of what we are looking for in this motion, I don't think a default against the defendants is too harsh a remedy. They have acted in an outrageous way, in a deliberate way to this court and to the parties involved. However, short of a default, Your Honor, we believe that monetary sanctions are commanded by virtue of the fact that we've had to now file 2 of these motions. We had to defend against false and untrue affidavits, and that we should be reimbursed at a minimum for our legal fees, my client's legal fees that they have had to endure as a result of their behavior in their lying in the affidavit. In terms of the preliminary injunction, Your Honor, certainly I think we warrant a preliminary injunction to prohibit the defendants from using any Garja document or information, which also commands them to return all of the documents or information and destroy the copies they do have. And finally, Your Honor, I think it's very appropriate that PLS, MLS, and their agents be prohibited from soliciting or contacting or doing business with any Garja customer or vendor at this point, because we have established conclusively that they have stolen documents, used those documents inappropriately, and are operating unfairly based on their actions. And that is all I have, unless you have any questions for me, Your Honor.
I don't, thank you. Ms. Wood?
Thank you, Your Honor. When we previously were before Your Honor on the first motion for preliminary injunction, the court cited controlling principles with respect to injunction constructive relief. First, the party seeking injunction relief bears the burden of proof. Second, injunctive relief is an extraordinary remedy that should be used sparingly. Third, competition is may not be enjoined. It's only the unfair competition that may be enjoyed. And free employment, where employees are able to change jobs without onerous restriction, and keeping them in place is valid and valued and protected. These controlling principles continue to apply and continue to require the denial of plaintiff's motion as it relates to contacting vendors and customers. There are 2 things that have happened since this court last addressed plaintiff's request for this extraordinary relief. There were some Garja documents discovered, and in the initial discovery of those, not many documents, the defendants authorized and paid for a very extensive search of personal computers, the non-functioning laptop belonging to Rochelle Mauer, her Google Drive, and Colin Smith's personal email. Those documents, despite what counsel has said, have been produced, and we specifically, it is true, our production is not complete, but we specifically structured the production of our documents to make sure that the most critical documents, being documents that were discovered of belonging to Garja, were produced first and foremost, and as described in the well over 40-page letter I sent last week to Mr. Albright in response to his request to supplementation, we not only outlined exactly what we had searched, what we had found, and what we still have in the queue, which is not anything from the personal emails or the personal electronic devices, but we also included in an extensive list of the base numbers. So plaintiff does have from where each document produced was sourced, meaning was it from PLS, server, was it from Colin Smith's personal computer, his personal email, Rochelle Mauer's personal laptop, or her Google Drive. The other thing that has changed since we last were before this court on this very issue is that David Garsha, the principal or one of the principals of plaintiff, was deposed. And his testimony makes clear the plaintiff cannot satisfy now nor ever the burden of proof on the cause of action that the company has brought in this lawsuit. There is not a binding contract regarding confidentiality. David Garsha testified finally as to what his trade secrets were, and as I will go into in a little more depth in a minute, none are legally cognizable trade secrets. And finally, Mr. Garsha testified very clearly. He has not lost any business. He has not lost any contract, and he has not otherwise suffered any legally cognizable damages. And in fact, like what I'm hearing now for the first time today, that the loss of the Centurion is just a signature away from out of David Garsha's grasp. What we know is that the first time we noticed Mr. Garsha's deposition, he was not available for it because he was down in Tennessee meeting for Garsha Laboratory business. So that's the first I'm hearing about it, that Mr. Garsha thinks he's even in the crosshairs of losing that business. It is certainly not what he testified to at his deposition. Regarding the documents that were found, there's use of documents that were disclosed to this court and to plaintiff in the disclosure. Those documents were explained in our briefing, but I do want to run quickly through the utilization report that Mr. Donnelly just brought to your attention again. The utilization report, plaintiffs saying they're in that it's a sensitive document because it first identifies what tests were on for the Tennessee Department of Corrections, the testing capability of Garsha, the testing capability of PLS, and the testing capability of most laboratories are posted publicly. The testing capabilities themselves are not secret, and there is nothing that Garsha Labs does to keep those capabilities secret. They're public information. Second, they say, well, the number of tests that the actual utilization, how many tests were run in a particular period, is our confidential / trade secret information. It is not. That information belongs to the end user in that case, or in the case of the Tennessee document that Mr. Donnelly was referencing, is their information. How many tests, how many complete blood tests do we do? How many liver function panels do you run per month for our inmate population here in Tennessee? Those utilization numbers are then used when Tennessee or any other governmental agency, any other CHC for that matter, puts business out for bid, because to bid on information, you have to know what kind of utilization is being requested of you. Mr. Garsha not only knows that that's the concept, but he does business with vendors of Garsha who are also competitors, and in contracting with those entities as vendors, he shares the very utilization report with them, who are vendors / competitors, that he's now complaining about. We found and attached for you Garsha's utilization report, and that is attached as an exhibit from a motion that contains utilization information and pricing information. And in deposition, Mr. Garsha tried to explain away that that was old information from 2017. It is not. If you look at the exhibit that's attached to Exhibit 3 of our brief, which is Mr. Smith's affidavit, The second exhibit to that is the Maricopa County RFP response of Garcia for the contract year that ends in January 31, 2023 and began in 2001. So that is current information, not historical information. Regardless, it's subject to FOIA. Finally, with respect to the pricing information and the claimed misuse of that, it is true. Collins first sent a vendor a document that contains some Garcia pricing information. Within an hour's time, he resubmitted information without that, without the patient information either, and told the vendor that it was a mistake. However, in response to the accusation about Centurion specifically prices a percentage off Medicare. Medicaid. And so that the pricing information wouldn't have been relevant because it is dictated by the CHC in that specific case. Further, for the Core Civic RFP that PLS did respond to, and that we understand from Mr. Garcia that Garcia Labs also responded to. Neither got, PLS didn't get the business, and when asked for the reasons why, it was told that it was because its pricing was too high. The reason its pricing would have been deemed too high in the eyes of Core Civic is because, as Mr. Garcia himself testified, volume is everything. The volume of the lab, the work that the lab is currently doing for any customer in total, not one specific customer, will dictate the pricing, where pricing is given as an option by the CHC or the end user. And pardon me. And because PLS's volume is almost zero, Garcia's pricing would never even be relevant to PLS's business. With respect to turning to what David Garcia claimed on behalf of the plaintiff was its trade secret information, the far-reaching and efforts that Mr. Garcia takes to put everything from Garcia Labs under the umbrella of trade secret is not availing and legally inappropriate. He claims that the use of UPS, the United Parcel Service, is a violation of his trade secret. What law firm he used is a violation of his trade secret. And of course, its customers, contractors, vendors, and pricing are trade secrets. None of these are trade secrets. And any prohibition on confidentiality that David Garcia claims is based exclusively on the acknowledgement in the employee handbook, which we have briefed for you in the context of this motion and previously, is not a binding contract under Michigan law. Furthermore, Garcia's efforts to maintain the secrecy of the information that it claims to hold trade secret status to is non-existent. Again, he points exclusively to the employee handbook, and we have demonstrated a variety of ways that not only is this information able to be gathered publicly, but that Garcia himself disseminates the information to vendors, clients, competitors, in an effort to make a competitive bid. He admitted in his deposition that he was told that CHCs tell him about the ins and outs of the workings of other companies and uses pricing information from one company for the benefit of its itself in trying to get its vendors to, to lower prices to their satisfaction. So there is just not only not an effort to maintain the secrecy, the very way this environment works means that this information is not secret. Finally, Garcia has not demonstrated why any claimed trade secret derives independent economic value from being generally unknown. He only says repeatedly that it does, and gives no example, gives no information of how the information benefits his business by remaining secret. And I do want to underscore, thousands of documents were also produced by Garcia to PLS in the course of discovery. Much of that production contained utilization, pricing, and patient information. None of it sought the protection of the protective order that this court entered. And even at a second bite of the apple deposition, when those pieces of that production were introduced and Mr. Garcia was questioned about them, plaintiff also had the opportunity for a period of 10 days to invoke the protective order as to those documents, and plaintiff did not do so. In terms of success on the merit for the fiduciary claim, I'd just like to point out that while Mr. understanding and recognizing that whether a person is in fact a fiduciary is highly fact-intensive analysis, Mr. Garcia's deposition testimony also cleared that up. He views Ms. Mauer as a supervisor attending to the technical aspects of the lab, as explained in Ms. Mauer's affidavit. You run a CBC in one lab the same way you run in another. She's not in a position where she was negotiating price, contracts, services. That just wasn't her role. As to Mr. Smith, again, Mr. Smith is flouted as being a high level and an important and critical employee of Garcia by virtue of his salary. However, in previous briefing to this court, plaintiff disputed that Colin Smith had the ability to use a corporate credit card to purchase a flash drive. And one would think he really enjoyed fiduciary status of that high level employment. A simple purchase of a flash drive that probably cost $20 was probably not something that would need to be pre-approved by the owner of the company. Further, even if they...
You're going to have to conclude. I have a 3:30 hearing everybody's waiting on, and we're far from done in this. So if you can conclude soon, please.
Thank you. The status, I will just skip ahead. If the court determines that it is appropriate to issue an order to return and destroy all Garcia documents, plaintiffs are not opposed to that. Plaintiffs have already, defendants have already returned. And the only reason it hasn't been actually destroyed is because we are now in the context of active litigation. However, to issue an order precluding PLS from contacting former customers and vendors, particularly upon certified return and destruction of any property that might have existed, is not appropriate. And we request that the relief plaintiff's request in that regard is denied.
Okay, Mr. Donnelly, literally 30 seconds. Excuse me, Alan.
Thank you, Your Honor. Yeah, just quickly, Your Honor, they went through a lot of different things, but the long and short of it is, Your Honor, they focus almost exclusively on trade secrets. We have established conclusively that the information, not just the utilization reports, but the procedure manuals were specific to Garcia. And second of all, Your Honor, the mere fact that something is available through public means does not mean it isn't property of the person from whom it is stolen. So it's not enough to say that. And I think we've established that they improperly took the property of Garcia and used it, actively used it in the development of PLS and in the relationship with customers.
Okay. First of all, this is the second motion requesting a preliminary injunction. When I heard the first motion, I focused pretty much only on the lack of evidence that the defendants had taken or used confidential information of the plaintiff, and I really didn't go any further than that. And that's because all of the claims have some element of wrongfully using confidential information. So what I was really saying was I was assessing the likelihood of success on the merits. That analysis also went to the element of irreparable harm, because irreparable harm requires a particularized showing. So I found no evidence last time of anyone actually using confidential information, and consequently, there was no showing of likelihood of success on the merits or irreparable harm. Now it's come to light that the individual defendants, in fact, had the plaintiff's information when they left. They retained it, although they say inadvertently, and they've now, I believe, returned it. Although this information, I don't have all the information in front of me, obviously. One of them is a laptop that has hundreds of the plaintiff's documents on it. So I can only deal with what I've been given. And the plaintiff points to 3 items that have been submitted under seal as confidential documents taken and used by the defendants. I'm just gonna, before I go on to the elements, I'm just going to address those. So the first one is Exhibit I, which is a Garza Labs utilization report that Defendant Smith emailed to a potential vendor. And Mr. Garza, pardon me for my previous mispronunciation, I guess it's Garza. Mr. Garza, in his affidavit, says this is confidential and it would never be shown to competitors. But Mr. Smith's affidavit says this type of information is available off the internet. And not only that, in their response to this motion, they've attached an example. Although Mr. Garza says volume is confidential and used for projections, Mr. Smith explains more thoroughly how pricing is set and provides an online example of responses to RFPs that do include volume projections, or at least numbers of tests used. And I believe they also include volume projections, if I'm not mistaken. But Exhibit I, it doesn't really include any projections. Mr. Garza says you can make projections off of Exhibit I. So you can take the number of tests used and from there make projections going forward. Well, fair enough, but I can't conclude that there's anything confidential about this when you can see similar things, including from Garza Labs, that are out there on the internet. And as the defendants point out, as far as the number of tests utilized, the end user would have that information as well. So it's very difficult, if not impossible, to call that information confidential. And also, as everyone acknowledges, the clientele here are detention facilities, prisons, public institutions. So presumably all this information would be obtainable under FOIA from the end user, the prison or facility that is utilizing these tests. So I can't conclude that there's anything in the utilization report that is confidential. As I said, you can go online and see utilization reports just like this all the time with numbers in them of actual tests used. And as defendants point out, how else could anyone prepare an RFP if you don't tell the people bidding and the bidders who are responding what the numbers are that you're going to need? This type of information is widely available on the internet, and I can't conclude that there is anything confidential, inherently confidential about it. Exhibit L is a Garza Labs testing protocol. It's procedural. It talks about contents of reports, what's required to go into a report, and what the turnaround time is. And then it has a document that appears to describe the testing protocol for, I'm gonna, with my layperson's knowledge, I'm gonna guess that it's like for strep, it looks like. But this is standard diagnostic testing. As a matter of fact, the document in Exhibit L has a bibliography at the end of it that lists a bunch of medical journals. So, how to conduct a lab test for strep has not been shown to be unique to plaintiff or confidential to the plaintiff's business. And much of this is based on medical science. If you just look at the document itself, that's what it is. Exhibit M is also a Garza Labs testing protocol. This one is for mononucleosis, and the same thing can be said about it as Exhibit L. There's nothing unique to Garza Labs or confidential about it for the same reasons. It describes what would be standard testing, and it delves into the science behind it, which is supported by references to medical journals or scientific journals. So I don't think these documents are shown to be capable of being confidential when they contain information that's widely known, widely disseminated, easily obtained, and based on medical science. I suppose, though, that still leaves open the question of whether the plaintiff, as I suppose the plaintiff would be entitled to do, entered into a contractual agreement with its employees, specifically here, Smith and Maurer, to hold these types of documents in confidential status, because maybe to Mr. Garza, they were confidential. And I guess that could be the case. But that requires then that we go to count one, because that's the basis of count one. Breach of confidentiality is the basis for count one. And I have to assess that now. I did it before, whether it could factually succeed on the merits, but I have to analyze it again now to say whether it could succeed as a matter of law. In other words, did Mr. Garza did plaintiff Garza Labs have a contractual agreement with the employees that this type of document would be held as confidential? And that claim, breach of confidentiality, is based solely on the receipt and acknowledgement of Garza Laboratory Employee Manual that both Mr. Smith and Ms. Maurer signed. The plaintiff would have to show that this document is a binding contract in order to prevail on count one, because I know of no other basis to prevail on count one. Mr. Garza, although he may want these things kept confidential, has no basis for that if they are not in fact confidential, unless he entered into a contractual arrangement that they would be kept confidential. So there's a lot of cases that have been cited, and I don't think the plaintiffs actually cited any, but I know they did in the previously withdrawn motion. And the defendants have taken the liberty of saying, these are the cases that the plaintiff is going to rely on. So just, I read them all, and they're published, they're unpublished, and they're federal cases. And rather than go through each one and the facts specific to each one, they really boil down to general principles of contract law that are expressed in those cases and how they apply to the document here, the receipt and acknowledgement. The question is whether the receipt and acknowledgement was intended to create a contract, an element of a contract being mutuality of obligation, which means that, as one of the cases put it, and this is accurate, meaning either both parties are bound by it or neither party is bound by it. Here, and I don't think it's very useful to talk about, as they do in some of these cases, whether it's a separate document or part of the employee manual, because the real issue is the intent of the parties, and that is there an intent that they would be mutually bound by this. And I will say, though, that the receipt and acknowledgement, it's presented to me as a separate sheet of paper. I don't know, it may or may not have been attached to and made a part of the employee manual. But regardless, the receipt and acknowledgement begins by saying, this employee manual is an important document intended to help you become acquainted with Garza Laboratory. This manual will serve as a guide. It is not the final word in all cases. Individual circumstances may call for individual attention. So one, it indicates that it is not the final word, that it's only a guide. And two, it may or may not have been physically attached to an employee manual, but it certainly speaks of it as if it is part of the employee manual, because it begins by saying this employee manual is an important document. It goes on to say in paragraph 2, because the general business atmosphere of Garza Laboratory and economic conditions are always changing, the contents of this manual may be changed at any time at the discretion of Garza Laboratory. And then it goes on to say no changes in any benefit policy or rule, etc., will be made without due consideration of, etc. But the important phrase is sentence is the first sentence. The confidentiality provision then follows, and it comes as a bullet point under this statement. Please read the following statements and sign below to indicate your receipt and acknowledgement of the Garza Laboratory Employee Manual. And then it does, as I indicated, list a number of statements, including the statement, I am aware that during the course of my employment, confidential information will be made available to me, i.e. patient test results, customer lists, pricing policies, and other related information. I understand that this information is critical to the success of Garza Laboratory and must not be disseminated or used outside of Garza Laboratory's premises. In the event of termination of employment, whether voluntary or involuntary, I hereby agree not to utilize or exploit this information with any other individual company. However, as I've already indicated, while it says I hereby agree not to, the bullet point comes under the phrase, please read the following statements and sign below to indicate your receipt and acknowledgement of the Garza Laboratory Employee Manual. So it does not say sign this, and by doing so, you agree to the following statements, period. It says you acknowledge receipt of the Garza Laboratory Employee Manual. And then the final statement under the bullet points is, I understand that my signature below indicates that I have read and understand the above statements and have received a copy of the Garza Laboratory Employee Manual. So by signing, the employee is saying just what that said. I've read and understand the above statements, and I've received a copy of the manual. So even if this is a separate document or not from the employment manual, which by its terms it's not, it doesn't evidence the employee's intent to be bound by it, let alone the plaintiff's intent to be bound by it as a separate contract. Furthermore, there's a lack of consideration. I'd contrast it with the case POSSELIUS, where the, I think it was an arbitration clause in that case. That particular clause in the manual said, in consideration for my employment, and then went on to say disputes will be arbitrated. That is not the case here. It's not in consideration of employment. It's not in consideration of further employment. It's not in consideration of anything, and it's not an agreement. It is merely signing as an acknowledgement that you've read and understand the statement. So again, that does not show mutual intent to be bound. So this is the entire foundation for count one. And like I said, I cannot conclude that these documents that I've been presented with are confidential in nature. And now I can't conclude as a matter of law that there was some kind of a contract between plaintiff and the employees that they would hold any of these documents or any documents at all in a state of confidentiality. So there's no showing of likelihood of success on the merits on count one. As to count two, which is the Trade Secrets Act, the plaintiff has to demonstrate that something it claims to be a trade secret actually does have independent economic value from not being readily known to its competitors, and that plaintiff takes reasonable efforts to maintain secrecy. It's not enough just to say something is confidential. That is not enough to show that it's a trade secret. With regard to trade secrets, the plaintiff says Garza Labs is successful because it has accumulated over the last 50 years confidential, protected procedures, formulas, patterns, methods, techniques, and processes to distinguish it from its competitors. It derives independent economic value from these not being generally known by others. Garza Labs made reasonable efforts to keep this information confidential, including requiring all employees to sign the above-mentioned confidentiality agreement. Well, that does not give me enough information to conclude that there is a likelihood of success on the merits on the trade secrets claim in count two. First of all, it does not meet the burden of showing what is required, which is that there are trade secrets that actually have independent economic value from not being readily known to its competitors. And furthermore, there's no showing that this is anything the plaintiff takes reasonable efforts on to maintain secrecy. The only thing the plaintiff says is that there's a confidentiality agreement, but the confidentiality agreement, as I've just analyzed, is not a contractual promise. So there's no showing of likelihood of success on the trade secrets claim. Count three, tortious interference. The plaintiff alleges two types of business relationships that were improperly interfered with. First, employees were recruited by defendant Smith while he was employed by the plaintiff. The plaintiff says that without any evidence to back it up. And in defendant Smith's affidavit, paragraph 44, professional laboratory services was formed before I resigned from Garza, but it did not become operational until after I left Garza. I was not involved in the formation of PLS. I did not work to get contracts or customers before I left Garza. And I did not tell Ms. Mauer why I was leaving Garza or anything about PLS before I resigned. Furthermore, so the plaintiff has presented no evidence that employees were recruited by Smith while he was still employed by plaintiff. The defendant has the affidavit saying that he did not recruit Ms. Smith. And finally, I would point out that there's no, what I call a non-poaching agreement in this case, or none's been presented to the court. So no one's presented to me any authority that you can't say, and again, there's no evidence that this happened, but no one's presented to me any authority that you cannot say to another employee, I'm starting my own business. It'd be great if you would join me. Because, and I've seen in many cases where there is such a contract, no poaching our employees contract, but that is not existent in this case. The other claim with regard to tortious interference that the plaintiff is saying is that that the defendants improperly interfered with customers by using wrongfully obtained confidential information to steal customers. But again, I have analyzed the information and find it to be not confidential, either in fact or by contract. And furthermore, the customer that the plaintiff points to is Centurion. And Mr. Garza, according to his deposition now, it says that the plaintiff didn't bid on Centurion work in the past year, and that the only customer that Garza lost was Core Civic, and that was not lost to the PLS. So, and just like the no poaching, there's no poaching agreement. There is no non-solicitation agreement in this case. So the plaintiff presents no evidence to allow me to conclude there is a likelihood of success on the merits of the tortious interference claim. The fact that PLS, I guess, has a contract with Centurion is not evidence that it wrongfully stole Centurion. It is evidence that it has perhaps competed with the plaintiff, but in the face of no non-solicitation agreement, then I will not conclude that that is evidence of tortious interference. And furthermore, as I've already concluded, there's no evidence that the defendants used wrongfully obtained confidential information. The same follows with respect to the remaining counts: unjust enrichment and breach of fiduciary duty and inducement of breach of fiduciary duty, for which there is no cause of action in Michigan. But even if I interpret that as aiding and abetting breach of fiduciary duty, the same analysis applies. There's no showing of likelihood of success on the merits because all of these claims, and putting aside whether there's a fiduciary relationship for now, all of these claims turn factually on showing some evidence for likelihood of success on the merits that there actually has been some use of the plaintiff's confidential information to the benefit of the defendants. And for the reasons that I've already gave, I can't make that conclusion. There's also no showing of irreparable harm. There's no showing that the retention of the plaintiff's information after the defendant Smith and defendant Mauer left has caused any harm to the plaintiff. The documents shown to the court aren't confidential. The other documents have been returned and the defendants have agreed they will not be used. They won't use them. And again, there's no anti-solicitation contract and no authority to say that there's anything wrong with contacting the plaintiff's clients when there is no anti-solicitation contract. The harm in issuing an injunction in a case where there's been no showing of likelihood of success on the merits, no showing of irreparable harm, and no showing of trade secret misappropriation would be far greater than any potential harm from not issuing it. It would be wrong to issue an injunction without the necessary showing of likelihood of success on the merits and irreparable harm, and it would not be in the public interest. I will, to the extent that it's needed, if we need to include an order to return any of Garza Laboratories' reports or information, I think that's completely acceptable. But I will not issue anything that goes any farther than that for the reasons that I gave. Now, to the subject of the affidavits that were previously filed, the defendants, or I'm sorry, the plaintiff is asking for sanctions under MCR 1.109 E5 and 6. And it would, although I can't conclude, as the plaintiff would have me, that the defendants, Garza and Maurer, lied. There is evidence that they signed affidavits in a way that I would call careless, or with lack of concern for the truthfulness of what was in the affidavits. And of course, those were the affidavits saying we don't have any of Garza's information. I don't believe they signed any motion, but they did sign the affidavits. I'm certainly not going to sanction the attorney who signed the motion, or the response to the motion. Actually, it would have been, it was the response to the plaintiff's first motion for a preliminary injunction. But I'm not going to sanction the attorney. I have no indication that the attorney didn't make the inquiry that the attorney is required to make. But it would appear that Smith and Maurer did not use the due care that they needed to make before signing an affidavit saying that they didn't have any of Garza's information. So the court rule allows a sanction. I'm certainly not going to do the drastic sanction of default, but the court rule does allow any other sanction, including an order to pay the other party the amount of the reasonable expenses incurred because of the filing of the document, including reasonable attorney fees. So I think that even though I find that there's no required showing for a preliminary injunction, I think nevertheless we have to reasonably conclude that the plaintiff would not have had to bring a second motion had they had the documents and knowledge that the documents were in the defendant's possession the first time around. So I think it is justified to impose sanctions in the form of reasonable attorney fees for bringing the second motion for a preliminary injunction, and that would be imposed against the individual defendants, Smith and Maurer. But I would ask, because there is a reasonableness requirement, that the attorney fees be submitted to the court in a way that will allow the other side to object under Smith versus Corey as to the reasonableness of an hourly rate or the reasonableness of the number of hours. So I think that'll have to be handled under a separate submission before I have any basis for ordering what a reasonable attorney fee would be in this case. And that takes us to the motion to quash.
Your Honor, if I could just raise two things. You did technically have two motions that I think you, by implication, have granted. One is to accept the exhibits under seal, and two was acceptance of the privilege law.
Mr. Donnelly, I'm sorry, your audio just became terrible. Can you say that again?
Yes, I can. Sorry about that. There were two additional procedural motions that were filed. One was to accept the exhibits to our motion under seal, and then the second one was the accepting of privilege law. I just wanted to assume those were granted.
Right, I still have a hard time hearing you, but I was turning to the motion to quash, and then we have the motion to seal. I understand.
I apologize. I don't know what's going on with.
That's okay. Your audio was good before. I don't know what happened. Ms. Woods is terrible. I think she's got a bad internet connection because the video was pixelating and the audio was bad, but such is our life with Zoom. So I'm going to turn then to the defendant's motion to quash the subpoena to non-party Foster Swift and or motion for a protective order. And Mr. Story, are you actually appearing on that? I'm not clear.
I'm more here because as the deponent subject to the subpoena, I need to know what we're
Okay.
required to do because there's a privilege involved that belongs to the client. And when you serve the lawyer with
Yeah,
the
I get it.
subpoena, there's that difficulty of, trying to honor the client's desire to protect what is protectable.
Okay, then I'm going to go ahead and hear from Mr. Donnelly, I presume, on the defendant's motion to quash the subpoena and or for protective order.
Thank you, Your Honor. We obviously oppose the motion, and I hope my audio is a little better now. We oppose the motion to quash. Subsequent to the motion being filed, we did receive a privilege log regarding the documents held by Foster Swift. What we noticed there is that despite the fact that Colin Smith had said he had no contact with Foster Swift regarding the formation of PLS or any future business of PLS, we now know that he had extensive contact with the attorney at Foster Swift in October of 2020. Therefore, it's vital for us to be able to see what communications, since we have a claim for breach of fiduciary duty that he owed to Garja, that he had a duty of loyalty to Garja. If he was actively involved in setting that company up, he violated that duty. And what we need to see is what was communicated to Foster Swift in terms of documents. Did he use any of the documents that he took from Garja in assisting Foster Swift, whether it be WBE documents or any other documents? So we're requesting that those documents be released, as I think to the extent that he says he had no involvement with Foster Swift or was not working for PLS at that time, which we know now is not true. He has no privilege with respect to Foster Swift. That goes to the entity. And if he was not working with the entity at that point, then there is no privilege with regard to his communication with Foster Swift. But even if the privilege does apply to him, we need to see, we have no other way of determining what was given to and sent from Foster Swift regarding the formation and the early corporate decisions made for MLS and PLS.
All right, Ms. Wood.
I apologize for my connection, but I also want to just be very clear that the privilege logs and the non-privileged documents that have already been produced came from PLS, not Foster Swift. So we've moved to quash the Foster Swift production in large part because anything that Foster Swift, and has, PLS at least should have, and we produced the PLS's production log, and we produced non-privileged documents responsive to the request that they've asked for. So to trouble the third party, and we cited case law, it doesn't make sense. And to evade the privilege by a crime fraud exception in a case where there's neither an alleged crime nor fraud, and without the showing required by the very cases that plaintiffs cite to even invoke that privilege, is inappropriate. We think that the motion should be granted, that Foster Swift should not itself have to engage in the time to respond to the subpoena when PLS has already produced a very thorough privilege log and non-privileged documents attended to those requests.
All right, thank you. Mr. Donnelly, you want the last word quickly?
Yes. Well, the point being is that we have a limited method by which to get to what we consider to be the scheme that we've laid out regarding breaching not only the fiduciary duty, but they have not produced, as far as I know, Your Honor. And again, the production has been sporadic. They have not produced any correspondence with Foster Swift by Colin Smith to indicate what his relationship was and what he was being advised on. So the question being is, he has testified in one way that he had no contact with them, and we now have a privilege log that shows that he's lying, and therefore we have a right to determine and find factual evidence to be able to support our claim that he's lying, and we did contact Foster Swift and act on behalf of PLS while he was still employed by Garja and in a fiduciary capacity.
All right, thank you. Well, needless to say, this subpoena to Foster Swift is the law firm that assisted presumably Mr. Smith with setting up the PLS. So at issue here is potential attorney-client communications, which of course are privileged. The plaintiff is saying this. The plaintiff says, Smith and Maurer conspired to and did form a competing business in breach of their fiduciary duties to plaintiff, and they used the services of Foster Swift to wrongfully set up their competing business. Let's assume for a moment, without deciding, that they were high-level enough employees to owe a fiduciary duty. I've said this before and I'll say it again, forming a competing business while you're still employed by another one is not in and of itself a breach of a fiduciary duty. And that's important because if they didn't breach a fiduciary duty by forming a competing business, assuming even that they did that, formed a competing business while they were still at plaintiff business, if they didn't do that unlawfully, then there's no basis for getting this information from Foster Swift, because you can't say that Foster Swift was somehow in this conspiracy with them to do nothing wrongful. So a further analysis has to be done. As I've said, just forming a competing business while you're still employed with another one in and of itself is not a breach of a fiduciary duty. I'm going to point to the two cases that the plaintiff has relied on and cited prominently in the plaintiff's brief, and that is the Ajuba, AGUBA International case from the Eastern District of Michigan in 2012, and then the Prudential case from the Eastern District of Michigan in 2020. In the first case of Ajuba International, the employee orchestrated a covert scheme to secure departures of key management personnel, interfered with plaintiff's business relationship to advance his interests, and misappropriated trade secrets and other confidential information, Armed with plaintiff's former employees and trade secrets, the employee then created the competing entity and began an international campaign to compete against the plaintiffs. That's far different from what we have here, because there is no showing here that Smith and Maurer, although Smith may have started the formation of a competing business while still employed at Garza, there's no evidence at all that he used confidential information or misappropriated trade secrets or used plaintiff's business relationships while he was still employed by plaintiff in order to advance his interests in starting then his competing business. Same thing can be said about the Prudential case. There, the employee downloaded substantial amounts of confidential business information for his own personal use and actually solicited plaintiff's employees to join his planned competing business and used confidential information to solicit business from the plaintiff's clients and therefore breached his fiduciary duty. And again, that is not the case here. There is no evidence here that while still employed by the plaintiff, Smith or Maurer actually used confidential information or solicited the plaintiff's employees or solicited plaintiff's clients for the benefit of PLS. There's only evidence that Smith and Maurer, perhaps maybe just Smith, but that he took steps to set up a competing business while he was still employed by plaintiff. It's then an unjustified leap in logic to say that if they use the services of an attorney to assist them in setting up a competing business, even while still employed by plaintiff, that the privileged communications between them fall under the crime fraud exception. Just as there's nothing wrongful about forming a competing business while still employed, there is nothing criminal or fraudulent about a law firm assisting in that. To the extent that they may have given legal advice about the WBE, I think it's called, status, the status for a business owned primarily by a woman or women. To the extent they may have done that, and having done it maybe to Garza as well, I don't think that a law firm giving legal advice on how to set up a business or even how to set up a business to qualify for some special status has anything to do with an unlawful conspiracy or anything that would equal a crime fraud exception. So if they gave the same advice, if it's sound legal advice that anyone can obtain as far as the requirements of a woman-owned business go, anyone can obtain those requirements on the internet. If they give solid legal advice on how to meet those requirements to one client, are they conspiring then if they give it to another client that's forming a business while working for the first client? I don't think so. That's just providing legal services, but there's no indication of any crime or any fraud here. The fact that Smith and Maurer denied communicating with Foster Swift prior to leaving plaintiff's business or plaintiff's employment doesn't alter the fact that the conversations did occur apparently, at least by Smith, and that the conversations were for obtaining legal advice per the privilege log. The privilege log that I've now been able to examine, and for all of those reasons, I am quashing the subpoena to Foster Swift with no showing of any reason for the court to invade the attorney-client privileged communications. And last, we have a motion to seal the documents that I've already referenced as exhibits. I, L, and M. Did anyone wish to be heard on that?
Yes, Your Honor, to the extent that obviously this case continues, I would request that the documents be sealed to the conclusion of the case, rather than unseal them at this point.
Okay, any opposition?
They're plaintiff documents, but PLS does agree that the patient information should probably not be a public record. The other documents we don't think are appropriately sealed, but that's our position.
Okay, well, one of them does have patient information, and that's Exhibit I. That should be sealed. But I think that L and M should be sealed as well, even though I've spoken pretty extensively about those two exhibits and concluded that there's nothing confidential about them. I understand that the plaintiff feels differently, and perhaps a higher court will look at this. And I don't want to be wrong after the fact and then have confidential information out there and disclosed in the file. So I think it's better to err on the side of caution, and I will order those exhibits sealed.
Thank you, Your Honor.
Thank you, and that will conclude our hearing on these matters.
Your Honor, you want us to submit request for attorney's fees separately?
Yes, please.
Okay.